Good evening, and welcome to this deep dive investigation. Tonight, we are looking at a situation that creates a striking, almost cinematic contrast in the world of global politics and high stakes finance. We have a scenario where, on one side of the ledger, you have Donald Trump on the world stage, engaging with European leaders and projecting an image of immense geopolitical ambition. The source reports indicate a tense atmosphere, with discussions surrounding Greenland and even comments regarding Canada that have traditional alliances on edge. The narrative being presented from the podium is one of 365 days of success and a return to power that is reshaping international boundaries. But if you peel back the curtain and look away from the diplomatic summits, a very different and much more precarious reality is unfolding within the American legal system. While the projection of power is happening globally, there is a dismantling of financial power happening domestically. We need to talk about what is happening in the New York courts because it is not a theoretical threat anymore. It is a procedural reality involving the potential seizure of physical assets, golf courses, estates, and bank accounts. Let's analyze what is actually going on here. This isn't just about a lawsuit. It is about the mechanics of a business empire facing a liquidity crisis mandated by the state. To understand the gravity of this, we first need to break down the legal concepts at play, because terms like civil fraud and disgorgement get thrown around a lot, but their specific meanings in this context are devastating. The New York Attorney General brought a case rooted in civil fraud. Now, this is a crucial distinction. In a criminal case, you might be familiar with the standard beyond a reasonable doubt. That is a very high bar to clear. It requires near certainty. But this case was civil. In civil court, the standard is what legal experts call a preponderance of the evidence. Think of the scales of justice. In a criminal trial, the scale has to slam down hard on one side. In a civil trial, the plaintiff only needs to tip the scale ever so slightly, 51% to 49%, to show that it is more likely than not that the fraud occurred. The judge in this case looked at the mountain of documents, the testimony, and the bank records, and concluded that the threshold was not just met, but exceeded. The finding was that Donald Trump and his organization engaged in a systematic, years-long scheme to inflate net worth. Why does this matter? Because the penalty for this specific type of civil liability is something called disgorgement. Let's stop for a moment and explain disgorgement, because it is the engine driving this $460 million financial train wreck. Disgorgement is not technically a fine in the traditional sense. A fine is a punishment. Disgorgement is an equitable remedy designed to restore the status quo. The legal theory is that if you obtained money through illegal or fraudulent means, like getting a loan with a lower interest rate because you lied about how much money you had, you should not be allowed to keep the profit you made from that lie. The court is essentially saying, you made this money by breaking the rules, so you have to give it back. The judge ordered the return of roughly $354 million in these ill-gotten gains, but when you add the mandatory interest that has been accruing, the total balloons to over $460 million. That is a staggering sum of liquid cash to come up with, even for a billionaire. Now let's look at the mechanism of the fraud itself, because the details revealed in court paint a picture of reverse engineering. According to testimony, including that of Michael Cohen, the process didn't start with looking at the assets and calculating their value. It started with a number. The testimony suggests that Donald Trump would determine a desired net worth, a number that looked good for his brand or for a specific deal, and then instruct his financial team to back into that number. They would allegedly take the assets he owned, buildings, golf courses, development rights, and inflate their values on paper until the math hit the target. This brings us to the concept of valuation manipulation. In real estate, valuation is somewhat subjective, but there are guardrails. You cannot simply say an apartment is 3 times its actual size, or that a property has development rights that do not legally exist. The court found that this is exactly what happened. These inflated documents were then handed to institutions like Deutsche Bank. Why do this? Because when a bank thinks you are worth billions more than you are, they see you as a safe bet. A safe bet gets a lower interest rate. A risky bet gets a high interest rate. By presenting these inflated numbers, the Trump Organization secured hundreds of millions of dollars in loans at rates they likely did not qualify for. That difference in interest, money the bank would have charged if they knew the truth, is part of what the state is now clawing back. So, where does that leave us today? We are in a phase of enforcement. This is where the rubber meets the road. The state of New York is not waiting for permission. They are following the procedural steps to collect a debt. This introduces another terrifying legal term for any property owner: judgment liens. Reports indicate that the state has already begun filing judgment liens. A lien is essentially a legal clamp placed on a property. It is a public notice attached to the deed of a house, a building, or a golf course that says, "This owner owes money, and this property is collateral for that debt." When a lien is active, you cannot sell the property, you cannot refinance it, and you cannot borrow against it without first paying off the debt. It freezes the asset. But it goes further than just freezing it. If the debt remains unpaid, the holder of the lien, in this case the state, has the right to force a sale. This is what we call foreclosure or seizure. The list of properties potentially in the crosshairs includes some of the most iconic jewels in the portfolio. We are talking about the estate at Seven Springs in Bedford, New York. We are talking about the Trump National Golf Club in Briarcliff Manor. These are not just investment vehicles, they are physical manifestations of the Trump brand. The difficulty Donald Trump faces right now is the bond market. To stop the state from seizing these assets while he appeals the decision, he generally needs to post a bond. A bond is basically a guarantee. A third-party insurance company says to the court, "We promise that if he loses the appeal, we will pay the judgment." But these companies are not charities. To write a bond for $460 million, they usually demand cash or incredibly liquid collateral up front. They rarely accept real estate as collateral because real estate is hard to sell quickly and its value can fluctuate. The report suggests that finding a company willing to underwrite this massive amount is proving incredibly difficult. Without that bond, the shield drops. The state can proceed with seizing bank accounts and properties even while the appeal is moving through the court system. And this brings us to the timeless aspect of this story. Regardless of the political calendar, regardless of elections or titles, a court judgment of fraud is a permanent mark on a business record. The judge didn't just impose a fine, they imposed business restrictions. The ruling included bans on serving as an officer or director of a New York corporation for several years. For a man whose entire identity is wrapped up in being the ultimate New York businessman, being legally barred from running a business in his home state is a reputational blow that lands just as hard as the financial one. We also have to consider the transparency that this trial forced upon the Trump Organization. For decades, the true state of Donald Trump's finances was a closely guarded secret. It was a black box. Now, that box has been broken open. The secret financial records are part of the public domain. The entire world, including future lenders, partners, and insurers, can see the internal communications, the tweaked spreadsheets, and the discrepancies. Even if Donald Trump wins on appeal, and appeals are a standard part of the process, and reversals do happen, the evidence that was aired in open court cannot be unseen. The testimony regarding the inflation of assets is now a matter of public record. So, as we watch the headlines about Greenland, and we see the images of diplomatic meetings and the projection of global strength, we must keep one eye on the docket in New York. we are witnessing a rupture between political power and financial viability. Donald Trump is currently navigating a reality where he holds significant political influence, yet his ability to sign a check, run a company, or even keep the keys to his favorite golf course is being dictated by a court order he cannot control. The state has made it clear: pay the money, post the bond, or we take the assets. It is a showdown that defines the difference between the power of office and the power of the law. One commands armies, the other commands the deed to your house. And in this specific battle, the law currently holds the winning hand. Thanks for watching this investigation. We will keep monitoring the court filings as this unprecedented situation develops.